So thank you all so much for joining us for Till Death or Divorce Do Us Part. This is an action-packed webinar, and we always get a lot of questions following up. So we'll move through the material fairly quickly. As you have questions, if you can enter them in the chat, if it works and it isn't too specific, we will try to answer as we go through the presentation. However, there may be some questions that just get held to the end in the interest of time, but we will do our very best to answer all the questions that come up during the presentation. Just a quick commercial to let you know, we do have available a really great tool for your clients. This is the buyers and sellers in the transaction, and that is the Start in Here process. There is Start in Here mobile deposit, which lets them deposit their earnest money through their phone without having to make a trip into Chicago Title. A second part of this is the questionnaire that your clients will receive to answer questions that we need to guide the transaction. We need that information. And by answering through the link that they receive from us in an email, they are going to be delivering that information to us in a secure way that is not through email. Wire fraud is still out there and real, and we are trying to collect this information as safely and securely for your clients as possible. So if you have any questions, you can ask your escrow officer or your Chicago Title sales exec. And then we also, for our realtor agents right now, we haven't expanded it to lenders yet, have the In Here web portal and app that allow you to get push notifications when certain milestones like the EMD being received, the prelim being ready, client signings and recording pushed out to you by phone, as well as track the transactions and get information through either a phone app or the web portal. So again, you can't get this until you have a live transaction with us that is opened anytime after our rollout date, which was mid-September. But once you get that notification email that you're invited to join, please do so. And if you have any questions, again, check with your sales exec or with your escrow officer. Now on to our regularly scheduled programming. Got a little squirrel saying wait. And with that, I am going to turn it over to our speaker, Escrow Officer Anna Gettman, who has attended several training classes on probate, has dealt with a lot of probate, has dealt with a number of interesting divorce and separation transactions, and is here to share her expertise with you. Oh, Anna, you're muted.
Okay, good morning, everybody. Can you hear me? Okay. I was just saying good morning. I hope this day finds everybody well. I always love to jump on these Zoom classes and empower people and teach people. I've been doing this for over 24 years. And so I love my job, and I love to let everybody know what we do and how to help your transactions run smoothly. So not every transaction is a cookie cutter transaction. Not every transaction is a easy one. It builds character when they're not easy. I love a challenge. So in this class, you're going to learn, or you're going to be have a little bit of insight of what happens when you don't have a seller that's husband and wife, and they're both alive and they're both married, and all is copacetic. So if someone that holds title on the property is separated, divorced, or deceased, it takes time and documentation to make sure that our escrow is going to be able to close successfully and correctly according to how it's supposed to be. You don't want anything coming back to haunt you after we close, or your client, whether you have a buyer and your client calls you and says someone's not, knocking on my door saying they have interest in the property, or they were married to the owner and they were supposed to, be part of the transaction or get some of the proceeds. So you don't want that to happen. So today you're going to learn what needs to be done. If you come across a situation where it's not copacetic and it's not cookie cutter. So, okay. If you learned nothing else today, use this tip. Before every listing, pull the current vesting deed. You can contact us and unless you and ask for that vesting deed for your listing appointment, so you know who you are dealing with. You know, you're dealing with the correct parties at the time of your meeting to grab that listing. So it's always a good idea to take a copy of the last vesting deed, which you can get from us with a quick email, phone call, text, and we'll be happy to get that over to you. What to expect when you're divorcing. Not every divorce is amicable. So there are 4 potential scenarios that you may come across. So if you come across some sellers or even buyers that say that they're separated, a question that you might want to ask is, is it a legal separation? Because there is a difference. There is a couple that can separate just on their own terms. But there is such a thing as a legal separation, which can be filed with the courts. So that's one quick question that you can ask. You're probably wondering, why does it matter if they're legally separated or if they're just separated on their own terms? It does matter regarding maybe some, well, there is buyers too, but maybe some sellers that have incurred some debt after a separation. And so we do look at the legal separation file documents to if something should come up in our title search and one of the spouses is adamant that that debt does not belong to him or her, and that it was acquired, you know, post legal separation. Can you go back one real quick thing? Because I wanted to make sure I covered everything. And so that's why we would want to know if the separation was legal, is a legal separation, that it was filed with the court. Same thing with divorce, is filed but not final. People will say, oh, I'm divorced. Well, you need to ask them, yes, you filed for divorce, but is it final? Because if it's not final, we still have to get that soon to be ex-spouse to execute appropriate documents, because California is a community property state. So we do have to address that. And once the divorce is final, then we don't. With buyers, they just are considered as an unmarried person. And then if they are divorced and it's final, we will start asking those questions as for a seller, because if they are both on title, we need to figure out what's going to happen. If they're going to take, if they're going to participate in the transaction as a seller, or they're going to be deeding off their interest, or if they're going to be deeding off interest with consideration. So there's lots of questions. So if you come across those 4 scenarios, just ask a few questions, and then you'll know where what path your transaction is going to be taking. We will treat sellers or buyers as married and follow all the customary practices. So basically, if the divorce isn't final, it's as if they're still married. Like I said a few minutes ago, that we still require a spousal deed to be executed, whether they are, if they're buyers, if they're sellers. Again, those questions are going to have to be asked. Is the soon-to-be ex-spouse going to be part of the transaction? If not, are they deeding off with or without consideration? Sometimes we have this divorce documentation that instructs us how the transaction is going to go. So in that case, if there is a divorce decree that does outline what is supposed to happen with the property and how proceeds are supposed to be dispersed, any debt that is attached to the property, how that debt is to be handled. So if the divorce decree is available, we would definitely like to see it, because it would be helpful, because as you know, escrow only acts upon instruction. We do not interpret anything. We do not We do not assume anything. We act upon instruction, black and white, basically. When it comes in the area of separation and filing dates, it does affect the liens and the transactions, like I said before. So for instance, if a credit card went delinquent after a legal separation and it was only on one spouse, and they went ahead and filed, this is for us sellers, they filed for an abstract judgment and it was recorded, we can then use that that legal separation date to determine if that lien belongs to one or the other, or, you know, of course, the one spouse that is stating that they don't owe that money. Okay. Okay. Deed execution will, of course, will follow the customary guidelines as the marriage has not been resolved. So you're probably asking yourself, well, what happens? Okay, it's not, the marriage is not dissolved yet. It's not final. And what happens if the spouse just refuses to sign? Well, we can't do anything. We can't move. Like that spouse has to be able to, or has to be in agreement to relinquish their said or unsaid interest in that property, as far as a buyer is concerned. If it's a seller side, we do need clarity. We do need to know, you may not have a transaction if one of the spouses that are on title refuses to sell. So this is why it's so important to ask these questions at your listing appointment, should you find out that there is a divorce or separation situation with the sellers. Let's see here. So in the event that both sellers are, you know, whether they're amicable or not, in the event that both sellers that are soon to be divorced are participating in the transaction willingly, we do need instructions from the both of them how their proceeds are to be distributed. For example, I had an escrow where the divorce was amicable, and both sellers had asked me to divide the proceeds as 50-50. And so, which was perfectly fine. We can make separate, because they're both on title, we can make the proceeds separately to each individual. However, we have to have both individuals sign instructions that they are allowing 50% of the 100% proceeds to be written to the soon-to-be ex-spouse as an individual. So that's that's what we need as far as clarity, because even though they write 50-50, we have to have instructions signed by each seller to state it's okay. Because typically when a husband and wife holds title together, typically one proceeds check or one wire gets distributed in both names. So in this event, they would have to instruct us to separate the proceeds and write each separate proceeds in the individual names. Now, say the divorce isn't amicable and they are having a dispute on how to have these proceeds distributed. That I've had escrows where attorneys are involved, divorce attorneys involved. The divorce is not final, they're still in the midst of trying to figure out the divorce and assets and who gets what. I've had escrows where I distribute the proceeds to a attorney's trust account. Again, we only act upon instruction, written instruction, and both sellers, whether it's one seller or the other seller's attorney, both sellers have to be in agreement and sign instructions that we are instructed to send 100% proceeds to the attorney's trust account. And what happens, the reason why they do that is because they're in the midst of the divorce and they're trying to figure out assets and who gets what, so that those proceeds go and sit in the attorney's trust account. And once the divorce is final or they figure out what's going to happen, then that attorney will distribute the proceeds accordingly. And we often don't know or see what happens after the fact, because once we close and those funds are to the attorney's trust account, we don't, you know, it's not like they circle back and follow up with us. So, and then another, if the divorce is final, another scenario could be where we have a court order from a judge instructing us how those proceeds are to be distributed and to whom. I had several court orders say, you know, 100% of proceeds goes to one of the spouse, or 100 or proceeds, some proceeds go to, you know, different percentages, or I have to pay a certain debt off first, and then after, and the reason why I say that is because sometimes those debts are unsecured and we don't know anything about them. So we go on that instruction from the court order. So,
and I have a question from Rick Spain. He says he has a seller situation where the divorce has been filed, but is not finalized yet. The soon-to-be ex-wife has been paid in full for her share of the equity. However, she's still on title. So what needs to be done to ensure those proceeds are distributed correctly? What will we need?
so a spousal deed, even because I know it sounds funny that the divorce that we're referencing the deed as a spousal deed, because it's not final, they are a spouse. A spousal deed needs to be prepared for her to sign, and along with that spousal deed, instructions saying that she is executing that spousal deed without consideration in that particular escrow, because she's received her share of the equity already. She would sign that deed and specify that she's signing it willingly and knowingly without consideration, because escrow needs to know that they're not going to pay her anything out of that escrow.
Thank you.
Mm-hmm.
Ready for the next slide?
Yes, please.
I just have a quick question on the interspousal deed or spousal deed. Who prepares that?
Typically escrow does, depending on the situation. I've seen where if they're in the midst of a divorce, the attorney's office, you know, one of the attorneys prepares it and has it executed within their office by the attorney's notary. And the reason why I say this is because oftentimes the spouse that is signing off is very reluctant and is not, doesn't have a whole lot of trust. So this is the one and really very few times we will allow a document to be executed outside of our realm and a notary to be used outside of our approved notaries, only because of where the action is being taken place, the attorney's office. And of course, you know, they're bonded, they have just as strict rules, if not stricter than you know, us as a title company. So we would prepare it, or the attorney's, one of the divorce attorney's office would prepare it, have it executed. They can deliver it to our office. We prefer that because we don't want to have to wait for the attorney to have to file it and get it recorded with the county.
Thank you.
You're welcome. The buyer should have access to the divorce decree as a reference. So oftentimes we will ask for this item as a divorce decree to try to figure out which direction we're going to go in. So if you are sitting with your clients, just kind of give them a heads up that if they're in the midst of a divorce and they do have a divorce decree already prepared, that just kind of give them a heads up that the title company, the escrow company, is going to be asking for this. And the reason why I say that is because it's a very personal document. It talks about this marriage and what was, you know, obtained through the marriage and what's going to happen. So it's a very personal document. So people do get a little bit uncomfortable providing such a thing, even though it's filed. They still get uncomfortable providing such things. Just let them know that, you know, any document submitted to the escrow company, we do have a fiduciary duty to keep it confidential, and it just stays with us and is reviewed within the title department. So just a little bit of a side note, just kind of have that conversation with them and let them, just kind of give them a heads up that that's going to be asked for a copy of. The seller can use a divorce decree as a reference, but we will still require the spouse not in possession to sign an interspousal deed for a clean title transfer to the buyer. So again, we do have a fiduciary duty to make sure that the buyer is obtaining clear title, clean title. We don't want that knock on the door from an ex-spouse saying, this is my house. So this is the reason why. If the divorce was never initiated or finalized. So on the both buyer and seller sides, we have to, it's kind of sad in this day and age that people go missing. And they don't, they go out for, I'm going to go and get some things for dinner and they don't come back. Or they decide to separate and never file legal separation or never file for divorce, and they just go off on their merry little way and just figure that they're going to live their own lives separately, and of course lose contact. They have no idea. And you would think that this is very rare, but it's not. People do decide they don't want to be married anymore and they take off, and they're happy whether they have combined finances or not. So in the event that you have a client that is still married, but in their eyes, they are divorced, but they never filed for legal separation or they never filed for divorce, they are married and something still has to be done. So in that event, if the spouse is just missing or that they just don't know where the spouse is, they would have to file for divorce in the Superior Court. And once they file for divorce in Superior Court and the judge hears all of their evidence and everything, the judge will then grant the divorce and then issue a court order for the court clerk to execute the conveyance, the quote unquote spousal deed. So that is for someone that is just took off, just missing, and it's been years and I haven't seen him or her in 15 years. Now, in the event that a spouse is believed to have passed away or murdered or whatever you want to say, you don't file for divorce in the Superior Court. You would go through the quiet title action. That is still a court action, but that's the route that you would take. So I hope none of you ever have to have that situation, and you just maybe come across a missing spouse. Okay.
Okay, next slide.
Okay, so we're going into probate situations where there's a will, there's a better way. I have this more often than you would think come across my desk. I have a lot of people that inherit property and they're just lost. They don't know that there's certain steps that need to be taken in order for them to sell a piece of property that they've inherited through grandma, aunt, uncle, mom, dad. So if someone dies without a will, they are an intestate. Before any property transfer can take place, and through a search for potential heirs must be conducted. So if there is no will, the heirs would have to go through probate. Probate court would have to instruct us who has the authority to sell the property and how the proceeds are to be distributed. And the reason why I say that is just because a person has the authority to sell a property does not mean that they are going to receive the proceeds through the sale. It's not always the same. Okay. And so it is important to note that the probate is still required even though there is a will. So if there is a will, you are actually your client is actually in a better position, as if even though there was no, if the property wasn't held in a trust or there was no successor person, still on title, if there is a will, they can obtain a Hegstag order, because that will, even though we can't use the will, title cannot accept a will and use it as a way to transfer the property to the person that's inheriting the property, that will that needs to be presented to the court, and the court needs to decide, okay, this will is valid. This will is, this is what the deceased wanted. So we're going to issue an Hegstag order, and then that we can use as our documentation to go ahead and move forward on who has the authorization to sell the property.
What was the name of the order?
Hegstad. It's hard. It's a weird spelling.
How do you spell it?
Oh, you got me there. It's Hegstad order. I'm not
Okay.
that was my weakness. That's why I love autocorrect.
Thank you.
So the test date, the will creates a state that names the heirs and makes the path in probate clear. It gives you a blueprint for the distribution of the estate. So basically, what I had just overviewed of, again, we have to have some kind of instruction on how to proceed. Okay. When it is straightforward, no probate required. So joint tenants, if the only time we get in a little bit of a trouble when property is held as joint tenants is when, unfortunately, both people that are in title as joint tenants pass away together. So that's the only time that there is a little bit of a hiccup. But other than that, joint tenancy, if there's two people on title that held or on title holding joint tenancy, if one should pass, the other one automatically gets the property and they're considered as surviving joint tenant. Okay. Community property with right of survivorship is technically almost the same as joint tenants. The community property has some indication for tax purposes. We do not go into detail or or explain why it would be beneficial for someone to hold title as community property, but with those words following that, community property with right of survivorship does indicate that should one pass, the other one does not have to go through probate. They can continue as a surviving vestee. So if the property is held just as community property without those four wonderful words after that, you would have to go through probate. Okay. We do prepare those affidavit of death. So in the event that you come across with a client and a person on title has passed and they are holding title in these forms, we do need a copy of the certified copy. We need a certified copy of the death certificate to prepare an affidavit of death. So don't panic thinking that an attorney has to prepare it. No, we can prepare it. We have the ability to prepare it. All we need is a certified copy of the individual's death certificate. Revocable transfer on death deed of record. This is also no probate for trust. So death on deed is something that came about a few years ago. It's something that we don't see often. So the only thing I have to say about this is if you do come across that, we do have to get underwriting approval, and it is a case-by-case basis, because the reason why I say that is underwriting has to go through the chain of title and see what had transpired previous of this death by deed. Okay. What is the purpose of probate? Probate is a court procedure that directs distribution of assets of a decedent when there is a will or no will / trust. So you saw those few vestings in the previous screen. Another way that you do not have to go through probate is if the property is held in a trust. And then the trust documents will give us our guidelines of who has the authority to sell the property and who is the successor trustee. A will is proved to be valid and administration of personal and real property assets and debts of estate, and then determine errors, devices, and legatees, judicial determination of character and statute of vesting. So basically all these bullet points are what our title department, underwriting department uses to determine if there's red flags, red flags for vesting. So when we have someone that has been, that is deceased and it's not your cookie cutter joint tenant, community right with survivorship, the title department, underwriting department goes through these lists, tries to figure out, is there red flags? Is there something to be concerned of? Or can we move forward with instruction, as far as a probate order? Okay. Yeah, I'm sorry that the note is cut off, but I think it says there's no such thing as a quick close when you have a transaction that's dealing with a probate, whether it's financed or cash. If there is probate involved, you're not going to have a quick close.
And Anna, sorry, I clicked late on it, but we use the final distribution court order to determine what we can do, correct?
Yes. Final distribution order will instruct us on how to proceed with the transaction and what needs to take place as far as closing the transaction. So a little bit of a side note as far as probate. Don't get discouraged. Probates take a while, but that does not mean that the entire probate has to be final and closed in order for us to close our transaction. Oftentimes, if the probate judge understands and knows that there is that a pending sale or a sale is forthcoming, they will carve out that asset, that issue, and then they will maybe have a hearing just for that asset, that issue, and they would issue a letters of administration. The probate attorney goes through a few documents that is necessary, requests a few documents that are necessary for the transaction to close. So even if a probate can take up to past and beyond a year, don't get discouraged. That doesn't mean that you're going to sit on a listing for a year. The probate attorney should know that if they can carve out that asset and present that asset first and foremost to the probate court and ask for authorization and permission to move forward the sale and request instruction how to proceed on the sale. In regards,
and we had a question that wasn't sure where to work it in, but it said this lot was purchased with a mobile home on it from a private owner. The seller husband was on the deed only. The seller died and the final payment was made to the seller's wife. How does the buyer get the deed of ownership? And I'm not sure that we may want to ask that Susan unmute to talk about whether she's talking about the land or the mobile home. If it's on a foundation or not, it could get technical.
Yeah, mobile home on it all depends. Permanent foundation, if it's not, they're two separate situations. Does she want to unmute?
It's on a permanent foundation.
Okay, so as I understand your question is there was only one individual on title that passed away.
Yes.
Okay, and the individual that received the payment was the wife.
Yes.
So I'm to believe that was a court order. So now your question is, how does the buyer obtain a copy of their deed?
Yes.
Okay, so if they went through escrow, then the deed was recorded and our customer service can just obtain a copy of the deed. I'm not sure as far as the way the deed was handled within the escrow company. If they never received the original deed, unfortunately, they may only be able to get a copy.
Okay. They didn't go through an escrow.
Okay. So there may have not been a deed then. If they didn't go through escrow, there may have not been a deed.
They're trying to get-
Were they not supposed to take ownership until they had made all the payments on the property and then ownership was going to be transferred?
Yes.
So Anna, if the seller held title by themselves, that we would need the wife to come into possession and then she could transfer the ownership to the new buyer. That would require an escrow, but would it require court action as well?
Yeah, yes. And my question to Susan is, was there a written agreement explaining the process?
No, there wasn't. There was no written agreement. It was just verbal.
Okay, that's sticky because there's nothing to present to the court.
Right.
So you would have to reach out, or they would have to reach out to a qualified real estate attorney and request their guidance, because
Okay.
that scenario is very, very sticky. And unfortunately, I would not be able to guide you in the right direction. So they would need to reach out to a real estate attorney.
Okay. Thank you, Anna.
You're welcome. Okay, the process of probate. So basically, I love this little cartoon. It keeps it simple. It's easy to understand. So the file petition for probate, published notice of administrator, hearing date on probate petition, letters issued. So and you can read through this on your own, but my little tip, the probate process can run smoothly and quickly, as long as your clients provide the appropriate documentation when requested in a timely manner. If they do not, especially now and I hate when this is used, but we're still dealing with delay due to COVID in even in the judicial system, everything government. We are still dealing with delays due to COVID, because when we request things, it's like, that's the answer that we're given. So I do encourage you to encourage your clients, if they are in the process or they do have to enter the process of probate, to have them stay on top of it, have them provide documentation when requested, because the faster they do it, the faster the probate process will be complete. Okay. But, this is the timeline, the roadmap through the probate court. It's not a scary thing. I promise you. It just people have to stay on top of it, because unfortunately, as title and escrow, we're unable to facilitate this for you. Our hands are tied. All we can do is just sit and wait until the appropriate documentation is provided to us so we can move forward on the sale.
Daphne Henschel had a quick question. Daphne, would you like to unmute?
Yes, I just have a question. Are we able to get a copy of this, the California probate process?
You know, this is not our flyer because
Okay.
we're not allowed to distribute this. It's
Okay.
not directly title and escrow related. So unfortunately, we do have something that we can send you, but it's not this cute. So,
Okay.
all right.
Okay. Thank you.
Okay, so here's the timeline. Again, this is something that is very helpful. As you see, the documents filed and action taken can take 4 to 6 weeks. Like I mentioned before, if your clients are on top of it, it can be shortened. What can't be shortened are waiting periods within the probate, because notices do have to go out to make sure that any possible errors out there were notified appropriately, and that the timeframes were given to anybody, to come forward. So in this timeline, it's typically, this is your average. If your client stays on top of it, it can be shortened, but what can't be shortened is actual timeframes that have to be given legally to any errors that are out there. Okay. Who gets the money in a probate sale? I think I mentioned a little bit of this before, because it doesn't mean that the administrator of the estate, the individual that is filing for the probate, does not mean that they're going to get the funds as an individual. If the estate is still in probate, the funds will go to the executor or administrator of the estate. Now, I know that sounds a little confusing because I just said that it won't not go. What will happen is the proceeds will be written to, for example, Anna Gettman, administrator of the estate of Joe Smith. And that's how the proceeds will be given. So in the probate attorney will advise as far as the financials and funds coming in. They will advise how, where, and when to set up an account for those proceeds to go into. Okay, because the likelihood of Anna Gettman being able to deposit that check into Anna Gettman's account at Wells Fargo is very slim to none, because they're going to see that it's written as administrator of the estate of. So the individual should be advised by the attorney of how this is going to pan out. And when it goes into that account, then that executor of the estate, administrator of the estate, will then, it's their fiduciary duty to distribute proceeds accordingly from the probate and how it's supposed to. Because the probate's just going to tell us. I've never really had, maybe one or two in the last 24 years, say to distribute funds outside of the administrator of the estate of. So, okay. If the estate has cleared probate, the funds will be distributed directly to the newly vested owners. Now, that happens about 25% of the time, where I get letters saying that the funds can be distributed to Anna Gettman, period. It all depends on what kind of probate, how big, how small the probate is, if there was a lot of assets, and if there was little to no errors, if there's not a lot of distribution to go out after the fact, after we close. Okay. And then again, your little reminder at the bottom. Okay. Trust. I love trust. Just as an escrow officer, off the record. It not only is clear cut, it makes your transaction easy. Because trusts really spell out like who's my primary, who's going to be involved. So it's very good when you do have a transaction that's in a trust, even if someone has passed away. If the trustee has passed away, it's clear cut. Now, don't want to give you false information. You do have some difficulty. You may come across some difficulty when you have a transaction where the trustee has passed and there's successors, trustees, plural, and not all trustees are in agreement in regards to a sale. Okay, I've had that a situation where property was in a trust, and the trust lines out who the successor trustees are. And half the trustees are like, we're selling this property. And the other half of the trustees are like, no, we're not. So just kind of keep that in back of your mind. Make sure that if you are dealing with a trust and there's multiple trustees, you want to make sure that you're meeting with all of them and that they all are in agreement to be in the transaction. Okay. I've had scenarios where one just did not want to deal with it and they resigned as a trustee. That resignation must be prepared by an attorney and signed either with the attorney's office, but that's a scenario that can happen. So basically, when a property is in a trust, the trustee, original or successors must be our seller. If the person is deceased, we will need a copy of the trust to confirm that that is correct. The correct party is selling the property. And if a affidavit of death of trustee has not been performed by the attorney, we will then need a copy of the death certificate, a certified copy of the death certificate, so we can prepare it. But in the event that it has been prepared by the attorney, it must be, of course, recorded. So sometimes people take it upon themselves to prepare documents on their own. In that event, we will just need a copy of the death certificate to verify that person did indeed die. So I know it's sad to say that, but people do these things. And when there is a trust, even though we are requesting a copy of, I guess I should go back. We will be requesting a copy of the trust. Now, again, this is a very private and personal document to your clients. Just know that we do not want the entire trust. We just want maybe the first 10 pages, because typically within those first 10 pages, it's going to tell us who the acting trustees are, who the successor trustees are, in the event one passes away, in the event one doesn't want to act as a trustee. It's going to give us the roadmap that we need. So just explain to your clients, yes, they're going to ask for this. You do not have to provide them the entire copy of it. They just need the first 10 pages or so, because again, this is a personal document. It talks about a lot of people's personal, private, financial situations. We do not want the entire copy. We just want the first 10 pages. Even collecting the first 10 pages, we still will draw up a trust certification so the client can sign certifying the trust and that nothing has changed, no amendments have been done, or any additional trustees have been added or taken away. Okay. Who gets the money when the property is in trust? Just like the estate, administrative estate, the proceeds will be written in the trust. So this becomes a problem when there's successor trustees and a bank account has not been set up, and we close, we wire funds to where the seller has indicated us to wire, or we write them a check and they're saying, well, I don't have a bank account. My bank won't cash this check because it says Anna Gettman, trustee of the Smith family trust, and my bank won't cash it. You have to have a bank account that matches the vesting, because we cannot write the proceeds to anyone outside of the trust name and the trustee. Okay. So just kind of maybe a little bit of housekeeping at your appointment. If the property is owned in a trust, just ask that question. Be aware that the title company will be wiring your funds to your account, and the account must match the trust name. Okay. Death during escrow, what things that can complicate our transaction. When someone doesn't tell us that the seller is dead. I've had this before, especially with very similar names, where a person is selling their parent's home. There was only one parent on title, and the individual happens to have the same name, senior, junior. We got to the closing table, and the seller's identification was presented to the notary. The seller's identification stated junior. The notary said, well, the name on here is senior. And he goes, oh, that's my dad. He goes, okay, well, your dad needs to be signing these documents, not you. And he says, oh, my dad passed away. Well, no one told us. And he thought he could just sell the property because his dad left it to him. And so that becomes a problem when somebody doesn't tell us, or the information isn't passed down or given to the real estate agent from the get-go that someone that on title is deceased. So we do kind of need to know that. Missing beneficiary, unpaid debts of trust. Basically, when there's old deeds of trust on title and we can't find the beneficiaries, or the institutional lender has gone out of business, that can become a problem. a challenge, but doesn't mean that it can't be rectified. In this case, without going into detail, we can request a loss note bond to bond around this situation. Okay. And then if the seller dies prior to the close of escrow, we can proceed to close if they already signed their seller documents and the deed, because they have already expressed their intent and their willingness to sell the property to the individual buyer. Okay. You can't swap buyers, because if the buyer gets swapped, then we cannot close. But if they have signed the deed, we can close. Okay. If the buyer dies prior to the close of escrow, we will usually cancel the escrow unless the surviving party wants to and is qualified to proceed. So if you have a husband and wife purchasing a property and one should pass away, we will sit tight, take instruction from the surviving buyer, and if it's being financed, making sure that the lender is still has the surviving buyer as a qualified buyer. All right, well,
Time for Q&A. If anybody has any additional questions, you can simply unmute and ask your question.
all right.
Wow.
I had a lot of questions during.
It looks like you covered it all. Well, then on that note, if there's nothing else, Anna, any other thoughts that we didn't cover on the slide that you want to share? Or are we good?
I think we're good. Just the main thing, I know I said it a lot. Just the main thing that I just want to hammer down is just ask questions. Like, you know, they're relying on you as an agent. You're the professional, you know what's going on, what can happen. Sometimes I feel like maybe some agents get fearful of asking questions because they don't want to seem like they're getting too personal or intrusive. Just remember, your sellers don't know what they don't know. And so I encourage you just to kind of preface saying, I'm only asking these questions because I want to have a smooth process and get your transaction closed successfully so you are happy at the end. So I feel like if you preface that and ask those tough questions, I think you're going to come out winning. So basically that's all I wanted to kind of hammer down on.
Great. Well, thank you so much, Anna, for all the great information. We will be making this recording available sometime later this afternoon, along with the copy of the document that I referenced on probate. But if you have any other questions, please just reach out to Anna or your sales exec, and we'll get you connected to the people that can answer them. Thank you so much.
Thank you, everybody.
Thank you.
Thank you all.
Have a good day.
Thank you.